If leaving money to heirs is of critical importance, one, make sure the rest of your estate plan, the beneficiaries and everything else, are as they should be. But also the converting into Roth might be a good idea. But you need to make an informed decision. Just don't react out of fear. If you are in a very high tax bracket in a high tax state, that cost of passing Roths onto your heirs could be very high. And the rules could change. They could get worse too. As I mentioned, our debt and deficit don't appear to be going anywhere anytime soon, so it's hard to believe things get better. But it's a case where you really need to make an informed decision.
Welcome to the Healthy and Wealthy Retirement, where your certified retirement counselor, Mark Struthers, takes a holistic approach to retirement, going beyond finances and embracing holistic well-being. This YouTube channel will address not just the financial part of retirement, but also the social, the physical, and the emotional parts of retirement. Everything you need for healthier, a wealthier, and a happier retirement.
Welcome to the Healthy and Wealthy Retirement. My name is Mark Struthers. I'm your host. Today, we're talking about Roths, ROTHs, Roth IRAs. And we cannot escape the Roth. The Roth is a pretty good account. We're talking about Roths in relationship to the recent Secure Act or acts and some of the clarifications and rules that have come down about the Secure Act. The main thing we're talking about is beneficiary designation. So what it means for your heirs. I think I have a Midwestern accent. I used to have a Southern accent, but your heirs, those who get your money, your stuff, your belongings, those who carry out your wishes. The Secure Act, when it comes to wealth transfer, meaning how the money gets to your heirs or what happens shortly thereafter, the word secure, the Secure Act is probably an oxymoron because it is anything but. So this is unfolded. The Secure Act had a lot of different things to it, but this has unfolded over the last 5 years-ish. There was a Secure Act 1 or 2. And what has happened when it comes to beneficiaries is the government wants more tax money sooner. And I think you're going to see more and more things like this as it tries to raise revenue because our financial situation isn't great. We're still a strong country. It could be worse. We're arguably still one of the strongest economies in the world. And even our financial situation, I think, is enviable. That being said, as the U.S. government tries to raise revenue, you're going to see kind of some of these backdoor taxes, if you will. So back in the old days, if you inherited an IRA, you usually had a long time, decades, over your life expectancy, to gradually deplete that IRA, meaning its effect on your taxes was often minimal because the distributions were so small. So pre-tax money out, taxable when you have it, and much like when you retire, or much like when you are over 70, 73, 75, when your RMD start, your requirement distributions, you're forced to take money out of your pre-tax accounts. And the same is true if you inherited an IRA, only it comes right away. So the meat of what happened with the Secure Act is instead of doing away with these stretch, and that's what they call them, stretch IRAs, they required that you had to get the money out sooner, in most cases within 10 years. And there's 3 classes of beneficiaries that have different rules around them. And none of this is meant to be legal advice. Please consult your financial advisor or your attorney. And we're by no means are we going to cover every single possible scenario that you could have. But we are going to give you a good idea of what your beneficiaries might have in store for them. So one, it's just good to have beneficiaries or just spend a little bit of time with a will or some beneficiaries. How much time you spend to keep your heirs from suffering the repercussions of the Secure Act, that's a different story. So we're going to start off by going through the 3 the three types of beneficiaries from least favorable to most favorable. And it's always weird to be talking about beneficiaries like this because someone died in order for you to be classified. I guess they have to do it. But the least favorable beneficiary is the non-designated beneficiary. And these do not qualify as designated beneficiaries. They are estates, or certain entities, if you will. Estates, charities, certain trusts. And, in many ways, you kind of make sense in that, the estate can be a default. So it's it's an entity and it wasn't really designated. Charities, I guess, is not really a person. And then certain trusts, that one gets a little more complex. We're not going to address that here. But if you are a non-designated beneficiary and the deceased dies before the required minimum distribution start or their required beginning date, there's a 5-year rule. So the funds have to all be distributed before the end of the 5th year. That's pretty harsh. That doesn't give you much time to plan. And if the RMDs have already started, then they continue on as if the deceased was still alive. They call it the ghost rule. Now you can do it sooner. And some of this gets to be complex. That if it's an estate, are you going to keep the estate going for that long? But bottom line is, this is a good reason why you try to get your beneficiaries in order. And to give you an example, we had a client where one spouse died, and as so often happens, the second spouse died shortly after. They'd been married a long, long time. And they had their beneficiaries correct. They had the spouse as primary. They had a trust as secondary, as contingent secondary beneficiary. Well, because they died so close together, the paperwork wasn't processed. It's tough, especially when you're working with some of these larger companies. But regardless, new ownership did not actually happen, but it couldn't go to the secondary beneficiary since it was supposed to go to the spouse, a valid beneficiary. And you might guess what happens. It went to the estate. Now, if something goes to the estate, anything in the estate has to be probated. So by the state, and we're using the word estate. So in this case, the state of Minnesota had to probate it. So a will has to be probated. And that's why with these non-probate assets like your 401k IRA, it's good to have beneficiary designations, pass ownership outside of the state's purview. You can also have a trust own things. A trust ownership would generally pass outside of the state's purview. It doesn't have to be probated. If something is probated, it could cost a lot depending on the state you live in. It also can take a lot of time. So in this case, it went to the estate. All the other accounts passed to individuals or to trusts. Nothing else had to be probated. So this one account had to be probated and took months and months. Like the case of Minnesota, it didn't cost a ton. Now if you have a lawyer doing this is where it can get expensive, then that gets to be very costly. So make sure you designate a beneficiary, and it depends on how much you care about making things easy on your heirs, but this kind of stuff is going to happen. So this is why no matter what you do, some things could happen that are out of your control. The second most beneficial category is the designated beneficiaries. These are the most common ones, and they're subject to the new, that's more people are becoming familiar with it, the 10-year rule. So, and these folks do not qualify as the most favorable category, the eligible designated beneficiaries, but they do have a better status than the non-designated. So when we are looking at the eligible beneficiary, at the non-eligible designated beneficiaries, If the deceased died before RMD started, before the required beginning date, then they are subject to just a 10-year rule. They have 10 years in which to get the money out. Now, some folks say, well, just push it off as long as possible. That may or may not be the best tax situation or investment situation, but they have that option. If the decedent died after the required beginning date, it's unlike the previous one with non-designated beneficiaries, where it was one or the other. This one actually still has RMDs and the 10-year rule. So 10-year rule and RMDs calculated using the longer of the beneficiary or the decedent's life expectancy. So they have to have RMDs for years 1 through 9 and then everything out by year 10. So that's kind of harsh, and it does add a lot of complexity. Some folks say, if my heirs are lucky enough to get anything, if anything's left, they can worry about it. But there is a lot to go over, a lot to handle with some of these new rules. And always keep in mind, very large distinction between when the spouse passes before the required beginning date, RMDs, or after. So the last category, eligible designated beneficiary. This is most often you could think of the surviving spouse. The spouse always gets preferential treatment. And there's also other ones that fall in this category. So disabled persons, chronically ill persons, minor children, some see-through trusts, benefiting persons. Like I said, there's too much complexity, too many examples to cover them all. But we'll go through a couple here in a second. So once again, we have to distinguish between if the decedent died before the required beginning date, RMDs, or after. So died prior to RMDs, it's the stretch or the 10-year rule. After the RMDs, stretch over longer of the beneficiary or decedent's life. I will say for the spouse too, who knows if they keep this loophole, but there's a way that you could technically initially claim 10-year and then switch to their own account. Again, that's where it does get pretty complicated. What does some of this look like? Well, let's go back to the non-eligible designated beneficiary. Let's say an IRA owner, let's say myself, dies at 75 after RMDs have started. My son, age 50, I'll use one of my son's name, Joseph, is a designated beneficiary and is subject to the 10-year rule, but also must take RMDs for year 1 through 9. Now, if I was to pass age 65, say Joseph is 32 at the time. I'm not sure if we did these numbers, they match up perfectly. Again, he's a designated beneficiary. RMDs haven't started, so he just has, say I died in 2025 at 65, and he must withdraw everything by December 31st of 2035, out within 10 years. There are many reasons why people like Roths in these situations, but one of the reasons is there are no RMDs if the account is a Roth. If the account is a Roth, the owner is assumed to have passed before the RMDs. So still a 10-year rule, or whatever the rule is, subject to, but our example, say Joseph is still subject to the 10-year rule, but the funds can stand. They're not taxable, and we're going to assume any sort of 5-year rule was met or anything else. Let's say a qualified distribution at the end of 10 years. It's not taxable, so he can let that account grow. And with a Roth, unless he needs the funds, there's really no harm in having the funds in that Roth IRA. And, generally speaking, you think about college financial aid or FAFSA, they generally don't look at retirement accounts, and I'm not sure what the rule changed if they would look at inherited accounts, but the Roth, they probably wouldn't, and that might be a good thing too, is just to leave the funds there. For eligible designated beneficiaries, we did mention that minor children are also considered an eligible designated beneficiary. One change, I think this was recently clarified, is that the child is subject to a little bit different rules. And I think an example is a good one. So we're going to say, I'll use one of my other sons. Will passes at age 10 in 2025. He's older than that. We'll say I died again. So Will is an eligible designated beneficiary. And in this case, he can stretch the distributions over his life expectancy, which are very small because it's such a long time frame, up until the age of majority, in this case 21, and then subject to the 10-year rule. So that's where some of these do get complicated. So very small required minimum distributions up until age 21. So from, if we will say I died in 2025, small distributions up to Will's 21st birthday in 2036. And then by December 31st of 2046, everything has to be out of the count. So RMDs up until age 21, and then everything out 10 years after that. And some of you might be saying, well, the age of majority is different for different states. In this case, it doesn't matter. This is federal rule. It's 21 for everyone. If leaving money to heirs is of critical importance, one, make sure the rest of your estate plan, the beneficiaries and everything else, are as they should be. But also the converting into Roth might be a good idea. But you need to make an informed decision. Just don't react out of fear. If you are in a very high tax bracket in a high tax state, that cost of passing Roths onto your heirs could be very high. And the rules could change. They could get worse too. As I mentioned, our debt and deficit don't appear to be going anywhere anytime soon, so it's hard to believe things get better. But it's a case where you really need to make an informed decision. There's a lot of fear-mongering going on out there, even by fiduciary advisors, trying to sell folks on Roths. And a lot of, like anything else, even those who are selling insurance products will sometimes cherry pick ideas. It's not that they're all false. Tax rates are historically low. Several decades ago, we had tax rates that the top rate was 70%, 90%. Now, the effective rate wasn't that high, but tax rates are low. They're going to stay lower here probably with the Trump administration being elected. But longer term, could rates rise? They could. The idea that you assume the absolute worst case scenario for tax rates in the future just seems unlikely, especially if you're probably going to be in a lower tax bracket. So you really do need to make an informed choice as far as how much are you willing to sacrifice now for an unknown future. Again, Roth's a great account. They are tax insurance. And another thing that's often told and sold, and I see it more and more, which I'm glad, is tax brackets are use it or lose it. To simply push on your tax balloon and have taxes pushed off as long as possible, not just for your heirs, but for yourself, isn't probably a good idea. So filling up lower tax brackets, the 0% brackets with your standard deduction, itemized deduction, whatever the case may be, 10%, even 12%. For most people, it's hard to believe that you're paying less than 10 or 12% on the federal side to fill up some of those brackets. And also, if you can factor in capital gains and so forth, be aware of the consequences, being aware of some credits you might lose, the Medicare surcharge, property tax rebates here in Minnesota are a big one. Be aware of all that. But the idea that you just avoid taxes as long as possible, you're probably going to end up paying more later in retirement. And then in the case, if passing on money to your heirs tax-free with more flexibility, that might be another reason. The idea that this is your only reason for doing it could be. I'm a little suspicious that that's a good idea. But again, it's your money. You worked hard. You saved for it. It's about making an informed decision about what happens to your funds, both while you're living and when you pass. Because financial planning is about making informed decisions. And if you take some time to do it, you're probably going to have a healthier, a wealthier, and a happier retirement. Don't forget to hit subscribe. Thanks for tuning in. If you enjoyed this episode, make sure to hit subscribe, leave a review, and share with your friends. Share the love. Make sure they have a healthier, a wealthier, and a happier retirement as well. Also, don't forget to subscribe to our newsletter for free resources and check out our website and social media pages for exclusive content and updates. See you next time.
Sona Financial, LLC, DBA Sona Wealth and Sona Wealth Advisors, is a registered investment advisor with the state of Minnesota. All views, expressions, and opinions included in this communication are subject to change. This communication is not intended as an offer or solicitation to buy, hold, or sell any financial instrument or investment advisory services. Any information provided has been obtained from sources considered reliable, but we do not guarantee the accuracy or completeness of any description of securities, markets, or developments mentioned.